Hi everyone, this presentation is about tort liability and you. What is tort liability? Tort law is based on the legal premise that individuals are liable for the consequences of their own conduct or lack of conduct when such actions result in injury to others. There's a couple of concepts that are needing a little bit more of the understanding of what this is. One deals with intentional tort liability, and the others are unintentional. Let's start with intentional. There are a bunch of different components to this particular one. We'll talk about assault, which refers to an overt attempt to physically injure a person or create a feeling of fear or apprehension of injury. There does not to be actual physical contact in order for assault to occur, which often makes it really difficult to look up a particular case in that regard. The other one is battery, is the actual physical deed that is threatened by the assault. Battery can be as simple as a slight touching or as forceful as a punch or direct contact from an object that is thrown. False imprisonment can be defined as an intentional confinement by direct physical means, threats, or by the assertion of legal authority. It is when the act of confinement causes physical or mental stress that teachers need to be careful. Next one is dealing with defamation. It's when a person can be held liable for false statements that tend to harm another person's reputation. Statements are defamatory in nature if they tend to expose one to hatred, shame, disgrace, contempt, or ridicule. There are two kinds, and one is slander for verbal and libel for when it's written. Now, the other type of tort liability deals with unintentional aspects. Mostly this deals with negligence or neglect of some kind. But there needs to be really four parts to this. The first is understanding that duty must be inherent. The duty a teacher owes to the students is a foregone conclusion as summarized in the legal doctrine of in loco parentis, literally defined as in the place of the parents. Teachers have a duty to anticipate unforeseeable dangers to students and to take steps to minimize those dangers, provide adequate student supervision, heighten especially for high-risk activities, have responsibility to report the need for maintenance of equipment and facilities, looking after the well-being of students with special needs in particular. The next part of this, for it to be unintentional, is dealing with the breach of said duty. Fail to exercise a standard of reasonable care. This means the court will judge a teacher's conduct based on how reasonable teacher would have acted under similar circumstances. These factors include the training of the teacher in charge, the experience of the teacher in charge, the student's age and grade level, the environment in which the injury occurred, the type of instructional activity, the proximity and presence or absence of the teacher in charge, and the special needs disability of the student if they exist. The next component of this is the proximate cause, showing that there is a logical connection between the breach of the teacher's duty and the student's injury that occurs because of that breach, which is going to be the next element. To analyze proximate cause, courts look to the issue of foreseeability. Was injury something that could have been anticipated by the teacher? And the last part, of course, I just mentioned is injury. A student sustained actual physical or mental injuries, and this must be proven. Now, I tried to select cases that provide some nuance to the understanding of these concepts, and maybe just some that I was curious about. Some of them are from the resource that we read, and some I just, kind of went and sought out. So let's go and talk about them. Okay, case number one. If I have trouble pronouncing, please forgive me. The Mulcahy and Diedrich. This was a defamation lawsuit. I believe this was from 1931, which is, you think there'd be something more recent, but it wasn't. What happened is that a teacher sought to recover damages from Diedrich, the president of the Board of Education, for defamatory statements made about Mulcahy's abilities as a teacher. The words related to the plaintiff's occupation, and it caused him not to be rehired. It was seen as unprofessional conduct. Now, the only time something like this may most likely happen in the scope of teaching would be to say like during an evaluation. In this case, teachers can appeal within a certain amount of time. It's hard to find this information. The only reason I know about it is from our union representative that he actually talked about in a meeting this year because there were some issues in regards to that. Some proactive measures, in this case, I believe would be advisable for the administrator to write down any place the teacher would be lacking and allow them a chance to correct the issue in a timely fashion while offering suggestions in a constructive manner before committing to a negative review. And the fact that it's written shows that, hey, it was goodwill faith, that, hey, we were wanting them to make changes, and then they made changes appropriately. And professional ethics here, as long as the teacher and administrator agree that acting for the benefit of the students is primary, that shared goal should aid in helping all parties improve the benefit to the community at large. Case number 2, Et versus Lynn Mar Community School District. This is a case of false imprisonment. Actually, a really interesting case. What happened on a band field trip to San Antonio, Texas? 9th grader Tony Et violated the school rules by smoking tobacco. As per school policy, which this is weird, Tony Et was sent home via Greyhound bus at his own expense, unsupervised. District was sued for false imprisonment and actually won. Surprisingly, the school was not sued for unintentional tort. There was something very weird about that in the actual, why they didn't actually pursue that. I guess they thought that, cases like that don't often tend to work for whatever reason where were the laws at the time. So I guess that's why they decided to do it that way. Now, all persons participating in a school-sponsored trip are deemed to have waived all claims against this district for injury, accident, illness, or death occurring during or by reason of the trip. And for the, just because there's a waiver doesn't actually mean that they couldn't be sued for these sort of things. So yes, that's what we have in place in my district, but at the same time, it's like, well, it's been overturned in cases before. So some proactive measures. Severely lacking for discipline as far as what is being said. Supervision duties should be outlined for teachers and chaperones, but nothing, of course, is said of discipline in our district policy. So we need to make changes for that. A discipline procedure should be in place to ensure the understanding of all participants. Professional ethics, the discipline procedure would help participants understand what's expected, proper behavior, and why, the safety of everyone involved. Case number 3, Home versus Manhattan Beach City School District. What happened? 10-year-old Michael Holm left school grounds on his own volition and was subsequently hit by a motorist, sustaining significant injuries. The mother sued the school district, as was the duty of the school to prevent Michael from leaving. This part of the case was dismissed because unless a school specifically acknowledges the supervision rules between campus and home, they can't be held liable. Now, that, like I said, that's kind of weird. It's, it is their duty to make sure to look after the child and supervise them. But if the student left on their own volition and for whatever reason the law said that they need to have some sort of policies, either saying that they do allow supervision in between campus and home, or they don't. And since they didn't have one, then they couldn't be held liable. It was kind of a weird situation. Now, if this happened for my school, this is a common problem at my school as it is an open campus, and most of the time teachers just mark the student absent with minimal consequences. Since most of the students are aware of their actions at this age level, they assume the risk. Remember, that was one of those things that was a part of foreseeable action, and since age and level, of our students, they have kind of awareness that, hey, I'm doing something that's risky. Well, it's kind of on the student at that point. Now, that doesn't necessarily mean that we couldn't still be sued for those things. It's still very possible. Like I said, some proactive measures in this, well, actually, let me talk about something real fast. The minimum consequence. I taught Apex class, which is an online class for remedial students, and I tell you, there was about 3 students who I literally did not see for 40 days. They would go to all their other periods and just skip 7th period, and I didn't see them. Nothing really was done to happen, and that's not necessarily a good thing. So a school in this area should lay out the behavior expectations for proper attendance, reasons for proper attendance, and consequences to be immediately followed for truancy and chronic absenteeism. That's feel like something that sometimes we're lacking with. Students should be aware that failure to attend school on a regular basis may subject them to unwarranted, dangers, poor school performance, risk of dropping out, and potential harm in future endeavors. Case number 4, Munn versus Hotchkiss School. What happened? During a field trip to China, 15-year-old Cara Munn was hiking with her class when she was bitten by a tick and stricken with encephalitis, causing her severe neurological damage that she was permanently unable to speak. Despite having a waiver in place, the school was made to pay $41.5 million in damages for breach of duty for supervision and welfare of the student. Now, reactive measures. As far as school trips go, the district shall provide an emergency number to be used by all field trip supervisors in the case of emergency or accident to ensure that in the event of an emergency, appropriate district and school administration will be notified. However, there's nothing that says anything about being proactive in this case. So I would say, on the blog where I was reading this, they were saying, well, should this really truly be held since encephalitis could be unforeseeable? I mean, okay, yes, there might be ticks, but just because there's ticks doesn't necessarily mean they might get encephalitis, right? And so it might not be they may not be deemed negligent because proximate cause is adequately determined. Is there a logical consequence because of the breach of duty to warn the student about the ticks, and then because they didn't warn them, they got bit and then they got encephalitis. Like I said, it's all about proximate cause at that point. But I still feel like warnings and preventive measures like a suggestion of bug spray or proper tie might absolve the school of litigation. I can't say that for certain, but that's what I would do. Professional ethics, in this case, the problem is foreseeable danger. A good rule of thumb would be to have a common sense of any inherent dangers, making known the inherent dangers and putting in place adequate preventive measures. Now I say adequate, let's not go overboard. And I feel like the courts would be, go along with that for the most part. The last case here is Brayacek versus Millard School District. 14-year-old David did not follow proper safety procedures as he had missed the initial lesson, I think it was like the first day of school, about safety, when a classmate was showing him how to swing a golf club. The two teachers were not properly supervising when David moved too closely, was struck in the head, knocked unconscious, and died 2 days later. Now, procedurally, we would call 911 immediately and then reach out to the office right afterwards. Other than that, honestly, I'm unsure. Interesting enough, when I clicked on the link on the district website about student concussion and head injuries, the response was, this document is not available at the current user level. So that was a little bit disheartening. But for as far as that goes, I'd say some proactive measures would be to, and I understand, it's extremely hard to keep track of what students know and don't know and whether they were there or not. Perhaps reminders of safety guidelines the same day and hyper-supervision. Remember, we talked about heightened risk, as being reasonable, because there is a greater risk of something happening. It probably should have been necessary for prevention in this case. Now, as far as this goes, professional ethics, the focus is always on safety, but special attention would need to be paid for the heightened supervision of the higher risk. So teachers would need to be aware that extra precautions are needed when the risks are greater. Now, I would like to say that most reasonable people would understand that, but things happen. So maybe teachers just need reminding of that fact. Right. And here are my references for the cases, the information, and board policies in that regard. All right. Thank you very much, and take care.